It's getting tense. Do I need a restraining order or an emergency order in my divorce? Hi, I'm Bill Farias, founder and CEO of Farias Family Law. And we just had a case a couple of days ago in which this was the issue. People are moving toward divorce and things were getting really tense in the home. There was some violence. And so the client had to take action. And I figured I would record about and create this content about how to think about restraining orders and emergency filings in the probate and family court. So, first of all, if there is actual violence or the threat of violence, or by law, the actual language is an imminent threat of serious bodily harm, then a restraining order is the way to go. A restraining order is the fastest and most effective way to get yourself into a safe arrangement with protection from the court. So that's how a restraining order works: is if there's violence, if there's any kind of abuse, threats of abuse, or an imminent fear of serious bodily harm, you go to court and you ask for a restraining order. I would suggest, if there is a possibility of the case also getting into the court system for family issues like custody or divorce, you should go to the probate and family court for the restraining order instead of the district court. It just makes more sense. It's easier for the courts to streamline the processes, and it also makes the most sense because it's just easier for the courts to update a restraining order in the probate and family court if the order actually originated there, rather than going back and forth between two different courts. So get the restraining order if there's a real risk, and do it in the probate and family court if there is a possibility that there will also be a divorce or a custody case, or obviously if you already have one in that court. Now, in terms of getting an emergency order, I would say, first of all, unless there is a real risk to your safety or the safety of the children, you should run it by an attorney before you file in the probate and family court for an emergency hearing. And the reason I say that is because we have seen a lot of filings that do not fall into the emergency category that are actually filed. And what I would say is there is a real risk if you are filing nonsense motions and asking the court to expedite your case without a real basis. There is a real risk that you will take a credibility hit before a judge. So you want the court to take you seriously, so that if you do have a legitimate emergency request, then they will grant it and they will hear you. If you are going to them with matters that feel to you like they might be an emergency, but they're really not, then you're risking your credibility. So I would say, whenever possible, you want to run it by an attorney before you rush in for an emergency filing. And sometimes that's not possible. Again, I think the litmus test is, if there is a real safety issue, then you need to act quickly because your safety, the priority, the children's safety is the priority. But if you have some time, run it by an attorney. And so an emergency filing in the probate and family court makes more sense when there is either a custody issue or a financial issue involved. So in other words, a restraining order is not going to be enough if you also have to deal with money issues and you have to deal with custody issues. A restraining order can cover those issues on a really high level basis, but on a restraining order, a court is not going to get into the weeds on those issues. And so those are issues that are a better fit for an emergency filing. So the best way to think about it is, if there's a real imminent risk to your safety or there's abuse, file the restraining order. Then for these other issues that feel like they're urgent, if there isn't a real risk to your safety and the safety of the children, run it by an attorney, and it is more likely to be a good fit for an emergency filing if there are custody issues and there are financial issues. And usually, to get into court on an emergency basis, there usually needs to be sort of a safety element. So if it's purely financial issues, it's harder to get in on an emergency basis. If there is some risk to you or the children, and it involves trying to get someone out of the home, to get to have exclusive use and occupancy of the home, to have that person, the other party, vacate the home, then that's usually a better fit for an emergency filing. So that's the best way to think about the interplay between restraining orders and emergency filings. If you have any other questions, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com, and you can find us on social @FariasFamilyLaw. Thank you. Have a good day.